The proliferation of drones have become another front in the war on privacy. In a case in the Michigan Court of Appeals, we find a question of whether a drone search is reasonable or not. So we'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here on the Constitution Study, where we read and study the Constitution. We teach the rising generation to be free. I'm glad you could join me. If you haven't heard, you can also find me daily, 1 hour a day on the America Out Loud Talk Radio Network. Just head to americaoutloud.com and find out more, or check out the announcement on the website, constitutionstudy.com. That's also where you can sign up for the twice a month Q&A sessions that I am still hosting, at least for the foreseeable future. You can also find this and other articles that you can share. And that's really what I want you to do. I want you to take the information that we're finding here and I want you to share it with others. It's the lack of information, or the outright misinformation, the misunderstanding of what the Constitution says and the powers that it grants to government that has led to a lot of problems that we have. So please share that information with friends, family, neighbors, social media, wherever. And with that, we'll talk about this case out of Michigan that involves a drone. In 2008, Long Lake Township filed a zoning complaint against Todd and Heather Maxson. An agreement was entered into to settle the complaint. Then in 2018, the township filed a civil action claiming that the defendants had, quote, significantly increased the scope of the junk cars and other junk material being kept on their property, quote, which, quote, constituted an illegal salvage or junkyard, close quote. Now, as proof, the township provided aerial photographs taken by a drone. The Maxsons moved to suppress the aerial photographs and, quote, all evidence obtained by plaintiffs from its illegal search of their property, close quote. They argued that the aerial surveillance of their property was an unlawful search in violation of the Fourth Amendment. The township argued that the use of a drone to photograph the Maxsons' property was not a violation of the Fourth Amendment since the property was visible from above. The trial court denied the Maxsons' motion to suppress the aerial photographs. They based their decision on cases like Florida v. Riley, which found that, quote, the visual observation of a defendant's premises from a helicopter did not constitute a search under the Fourth Amendment, close quote. This led to Maxsons appealing the trial court decisions, which brings us to the case I'm reviewing today. In general, courts do not consider something a search if the item observed was in plain view. The idea being that if you expected something to be private, you would have not put it where it was publicly visible. In the case of California v. Ciarello, the Supreme Court found that observing someone's property from an aircraft at 1,000 feet did not violate the Fourth Amendment since the aircraft was operating in publicly accessible airspace. A few years later, the court found in the Florida v. Riley mentioned above that observations from a helicopter flying at 400 feet also did not violate the Fourth Amendment. Now, these cases are the basis by which the Michigan Court of Appeals made its decision. In a 2-1 decision, the Michigan Court of Appeals found that because the Maxsons had taken steps to prevent observation from the ground, they had an expectation of privacy, at least against casual observation. The court found that, quote, we conclude that, much like the infrared imaging device discussed in Kilo, low-altitude, unmanned, specifically targeted drone surveillance of a private individual's property is qualitatively different from the kinds of human-operated aircraft overflights permitted by Ciarello and Riley. We conclude that drone surveillance of this nature intrudes into persons' reasonable expectation of privacy, so such surveillance implicates the Fourth Amendment and is illegal without a warrant or a traditional exception to the warrant requirement. In the Kilo case mentioned, police used an infrared imaging device to scan the building for heat which emanates from the high-intensity lights used in indoor marijuana grow houses. The Supreme Court held that since these imaging devices were not generally available to the public, using them constituted an illegal search. Apparently, in the eyes of the court, using an unmanned drone to surveil private property is different than using a manned aircraft. The court found that while a hovering helicopter does not violate a person's property, a drone does. Karen M. Fort Hood dissented from the court's opinion. She claims that the use of a drone is indistinguishable from that of a helicopter when it comes to the Fourth Amendment. So who is right? The majority of the court or the lone dissenter? While I believe the majority came to the right decision, I also agree with the dissent that the difference between using a drone or a helicopter makes little difference in a question of privacy. While a helicopter is quite noisy, I doubt anyone would run outside to cover up their backyard should they hear one approach. In this case, I believe both the majority and the dissent miss a very important point. The question that did not appear to be considered by the court was the intent of the Fourth Amendment itself. Quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." The Fourth Amendment does not protect us from unreasonable observation, but from unreasonable searches. From Webster's 1828 dictionary, search is defined as, quote, "to look over or through for the purpose of finding something, to explore, to examine by inspection, as to search the house for a book, to search the wood for a thief." Now, courts have conflated the Constitution's protection against unreasonable searches into a right to privacy. Now, while there is an element of privacy involved, the intent of the Fourth Amendment is to protect us from snooping government officials, not from any specific method of that snooping. If a law enforcement officer sees something on your porch while driving through the neighborhood, we wouldn't consider that a search. Similarly, if someone is in a police helicopter and observes something in your backyard, that is not a search. If, however, an officer parks outside your home or hovers around your property in a helicopter for the purpose of finding something, then they are searching. And unless they have a warrant or reasonable exigent circumstances, that is a violation of the Fourth Amendment. If the Long Lake Township had probable cause, supported by oath or affirmation, that the Maxims were violating the law, then all they had to do was get a warrant, and the drone surveillance would have been reasonable. Whether the township did not get a warrant because they didn't have probable cause or because they were just too lazy to bother with it, well, that's a discussion for another day. Now, while I am happy for the Maxims, I am concerned by the ongoing abuse of the Fourth Amendment. By focusing on privacy rather than the searches, the courts have twisted themselves, and by extension everyone else, into knots with questions of where and when someone has an expectation of privacy. If those on the court would use the language of the Constitution and decide cases based on the reasonableness of the search rather than the method used, not only would our rights be better protected, but we would have fewer twisted court opinions like this one to deal with. So what appears to be a simple case out of Michigan turns out to have a lot more import. And a case where the court found the correct answer was still done for the wrong reasons, perpetuating more problems. I find it amazing when people tell me that the Constitution is complicated and hard to understand. It's not the Constitution that's hard to understand. It's the lawyers and the judges trying to get their way out of the Constitution that makes it hard to understand. A search is a search. If the government is looking for something on your property or on you or in your papers, that's a search. Where they are should be immaterial. The process they use should be immaterial. But again, courts, not the Constitution, have conflated searches with privacy and come up with all sorts of rules, stacks and stacks of rules, that bears little resemblance to what the Constitution actually says. So whether you live in Michigan or not, this case should be interesting. It should make us think, what is a search and what makes it reasonable? Now, according to the Constitution, a warrant makes a search reasonable. They've gone to court with probable cause and evidence of that probable cause, at least by oath or affirmation, before someone searches your home or your person or your papers. And common sense says, well, if time is of the essence, if a law enforcement officer is in pursuit of a criminal, especially a felon, we don't expect them to stop and call in for a warrant when they reach your front door. It would be reasonable for them to enter solely for the purpose of apprehending and searching that individual, not for searching your house. And don't even get me started with the third-party doctrine, this goofy idea that the court came up with, that if you take your documents and you give them to someone else to hold for you, suddenly they don't have any Fourth Amendment protection anymore. So this is an interesting little case. I thought it was worth discussing and bringing up. I hope you enjoyed it. I hope you'll head to the website, constitutionstudy.com, find out more. Hey, I hope you'll head to constitutionscholars.com. That's the website where we're getting together. We're not only studying the Constitution, but you have the chance to learn how to study and how to teach the Constitution to others. So check those two websites out. Again, that's constitutionstudy.com for these articles and these videos, and constitutionscholars.com to really engage with friends, neighbors, and become more of a scholar yourself. So I hope you enjoyed this. I hope you found it interesting. I hope you found it enlightening. I hope it made you think a little bit about your right to be protected from an unreasonable search. And I hope to see you here next time on the Constitution Study.
One thing